Well, the commercial reality is if the two don't match, what's the employee going to do about it? What are their rights? So let's say that it said it was, you know, £20,000 a year and the job was only £18,000 a year. Well, the employee can not sign the contract and not take the job. But they have no, you know, they can't sign the contract and then argue they're entitled to the extra £2,000 a year because they signed the contract and they have agreed to the terms. I mean, you could potentially have an argument for misrepresentation, but what are your losses? You don't have any employment protection because you haven't been there 2 years. They want to be looking closely at what the advert says and then making sure that the contract marries up with what they think they're getting, not only before they sign anything, but before they hand in their notice at any existing job, because of course once they've done that, there is no comeback against the employer, if the new employer, if they then decide, no, this wasn't what I thought I was getting, this isn't what I want to do, because their legal rights just don't exist. I had a client in the last couple of weeks who we negotiated a fairly complicated bonus structure for, signed the contract, and then a few hours after they signed the contract, he was asked whether or not he actually fancied being self-employed, even though it wasn't a true self-employed status, because it had certain tax advantages. So I talked the client through the pros and cons of what he was doing, but at the end of the conversation said, but you need to ask yourself, if this is what the company does, are you sure you want to work for them? Because it says something about the company. But that's a commercial decision. I can only tell the client what the pros and cons are.